it's her expectation that she's going to take along the children, a substantial portion of our client's paycheck, at least in the form of child support and potentially in the form of maintenance, and the better part of the marital assets. Welcome to another segment of Cache Counsel. My name's Joe Cordell. We're going to pick up with some of the topics we talked about last time, and we'll see how far we get today. I want to cover two areas that I think are important and I think sort of foundational in terms of helping you understand the principles of estate planning. Stepping to a sort of helicopter view here, where our objective, remember, is to sort of inform you as to how you can better manage your assets, to protect your assets, not just through the process of divorce, but thereafter. And I think a piece of that we can't afford to ignore is the issue of estate planning. And in some people's opinion, estate planning may not seem as sexy or as interesting as some of the areas of asset protection, offshore planning and things such as that are more exotic. The reality is that it can actually provide more financial benefit than these other, arguably sometimes more interesting discussions. So I think that's critical, that if you're going to think about asset protection, you've got to understand these basic concepts. And one of the problems that I see happening regularly, and I see this even among many professionals and among lawyers even who don't deal in the estate planning field, is that when they decide to do this sort of thing, they're virtually hostage to the opinions and the perspectives and the philosophy of whatever lawyer they go to that does understand estate planning. It's a very esoteric area of the law. And to the extent that you don't understand the sort of moving parts of estate planning, then you're going to pretty much be at the mercy of your lawyer's opinion as to what he or she thinks you should do. Now, obviously, I'm not an opponent of your listening to your lawyer's opinion, and in fact, more often than not, following that opinion. But at the same time, at the end of the day, remember, you're the person who is the captain of the ship, and you have the responsibility for making those decisions. You can listen to your technical guys, and they can advise you as to how you achieve your goals, but you have to chart the course. You have to identify the harbor to which you want to ultimately arrive. You can't have your lawyers defining that harbor, and it happens all too often in estate planning that the lawyers are the ones who are making decisions about priorities. You know, is your emphasis primarily on preserving assets for your surviving spouse, or is it more for the children? Do you think there should be spendthrift provisions? Are you concerned about the possibility that one or more of your children may be a bit prodigal and as a result prone to dissipate the assets? I mean, there are a variety of issues that lawyers, if given their leanings in many cases, they'll tend to use this sort of off-the-shelf product. And this product makes certain assumptions about the needs and expectations of various people in given situations. It represents the sort of bulge of the bell curve. So do you always conform to that point in the middle of the curve so that something pulled off the shelf that contains all of those requirements and all those expectations is going to fit you? Well, that's a big assumption, because by definition, most people are not at the center of the bell curve. As a matter of fact, very few people statistically can be at that center. Everyone else is either to the left or to the right. So I'm suggesting to you that you've got to play a participatory role in your estate planning process. You can't be vulnerable to your eyes fogging over when your lawyer starts running through these terms. And it is, again, it's very technical. It has a lot of tax law in it, has a lot of historical baggage that carries a huge weight in terms of the way the law is interpreted today, as much or more, quite frankly, than many areas of the law. So what I want to accomplish here is I want to give you guys a sort of broad understanding of the principles of estate planning, so that when you do get around to, and I strongly encourage you to get around to doing these critical things relating to your financial future and that of your family, when you do that, you're going to be in a much better position to participate in that discussion. This is our philosophy, incidentally, with Cordell and Cordell when we talk about the domestic relations side. Those of you who are regular visitors, and I hope you all are, of DadsDivorce.com, you know that Dad's Divorce is about informing you. It's about arming you to be most effective as a client. And an effective client is a member of that team that will determine the outcome of his case. And to the extent that you're entirely passive throughout your domestic relations case, then you reduce the probability of achieving your goals. Even with our brilliant lawyers at Cordell and Cordell, you still reduce your chances of success if you don't take the time to be the best client you can be. And the same thing applies when we talk about asset protection. So in Cache Counsel, that's our underlying objective here. Now, I'm counting on many of you having watched some of the previous segments, and those that you haven't, you can certainly go back and do that to sort of bring you a little bit up to speed along this road. And some of the things I mentioned today will cover that ground, at least to some extent. However, I'm going to try to not be redundant any more than I have to be. So I will ask that some of you who have not seen the previous segments that you take a few minutes and try to look through those. Let me start out today by talking about what is really elemental. It's critical if you're going to talk about estate planning. Even if you're in the process of divorce now, I have to talk to you about the issue of the unlimited marital deduction. And I'm going to make the assumption that some of you, incidentally, are happily married now. Some of you are not happily married, but I'm confident will be someday. And as a result, you've got to understand how the tax law works, how the estate planning works when it relates to a spouse. Many of you do not realize that you could die with $1 billion if you're married, and at your death you would pay no taxes, no estate taxes on that money. That may sound like an incredible statement because all of us have heard about how onerous it can be at death, the taxes that are triggered. And estate taxes are onerous, up to a maximum rate of 45%, and you can get there very quickly under these compressed tax rates. But yet you can dodge all that tax even if you die with $1 billion, if you're married and your spouse survives you. And that's because of what's called the unlimited marital deduction. What the IRS decided in a rare display of largesse, not that it was largesse, what the IRS decided was, years ago, decades, that they were going to allow spouses to postpone payment of taxes until the death of the latter of them. So what it means is that the tax man is willing to wait until after the second spouse dies in order to collect the taxes on that entire estate, what portion of it is left. So let me give you an example. You know, we've talked about before the fact that you have a $2 million lifetime exemption. So that means if you die with $2 million, you won't pay any taxes at all, period, without the marital deduction trust. But what if you die with $4 million? So you have $4 million, you die, and so you're $2 million over, and you're vulnerable to this 45% tax. However, because you have a surviving spouse, that person would take those assets, they would own them at that point. Now they may, during their lifetime, sell them, they may use them up, and if they use them up, then of course they won't be taxed at the conclusion. If they sell them, then by definition there's a substitution of another asset, so I'll assume that doesn't net you any advantage. But then at the end of that person's life, then whatever's left at that point, whether it's the $2 million, whether it's less, whether it's more, there would be tax at that stage. That's the basics of the unlimited marital deduction. So you've got to appreciate that very simple fact of estate planning in order to understand all the things that flow from that. Because from that, there's a lot of room for creativity and there's a lot of room for planning. Now let me introduce another piece, another critical moving part when you talk about basic estate planning for couples. Remember that you have this $2 million exemption, and that applies to each spouse, and it's a lifetime exemption. So now you can use that up, incidentally. It whittles away at that to the extent you use up to $1 million in gifts in your lifetime. That would be credited against that $2 million. But let's assume you make no gifts during your lifetime. In other words, you don't take advantage of the lifetime credit of $1 million. And so you have this $2 million credit available at your death. Using that example a few moments ago where you have $4 million, you know, you can do even better than the scenario I described. You know, in that example, you avoid entirely any tax at your death. Your spouse will, let's assume, just have income and dies with the same amount. So there's $4 million at that stage. So at that point, she would have her $2 million exemption available, we'll assume, that it wasn't used. And as a result, there's $2 million to be subject to tax. So if you have $2 million, we'll assume a 45% rate applied to all of that, so approximately $900,000. So you have $900,000 that would be taxed. Now that's a lot of money. That very easily you can dodge that bullet. And this is one of the reasons you have one of the basic notions of marital estate planning is what's called an A-B trust. And that's the idea of using a second trust called a bypass trust, a credit shelter trust, using a second trust to take advantage of your exemption. In other words, rather than just letting it fall by the wayside, the